if you agree. So Michael, please.
So thanks. It's been a great discussion, great day so far. I hope I will not take it down. In the first session and in some of the other sessions, obviously we spoke about various legal concepts. And I keep reminding myself that the legal concepts are just a tool, and substance should govern and win over form, right? So it's perfectly understandable when lawyers who face a case, they try to fit in existing legal categories, but we as academics, we can rethink and challenge those categories. So in another paper that we have sort of mentioned in the video, but it's not the posthumous paradox paper, it's something else, which we haven't yet published. We sort of look into the idea of digital remains and break it down. And what we see there is actually not one category, but 4 separate ones, which in the literature, you, Dina, and Lillian, and others, Chris and Dave and others have sort of referred to it, and also the scholars who are not in this workshop today. The first category is the easiest one, it's property. Bitcoins. When someone dies and leaves behind bitcoins or an avatar which is worth money, Adina, you've written about this, things that are actually worth money, it's easy, we can think about them as intangible property, and regular inheritance law applies. Whether there's a will or there's no will, we know how to deal with it. We have ready-made legal tools to deal with that. A related category is information about property. And this is increasingly an issue because, most of us do our banking online. There are hardly any papers related to banking, at least not here. Information is about property is needed in order to allocate the property according to inheritance law. Now, information about property may reveal personal data. It may reveal private issues. For example, if someone had a bank order to send money every month or whatever to someone, and oops, now we reveal that there's a child who the previous the family didn't know of, etc., or something along those lines. Or a donation to, something that the rest of the family was unaware of. So information about property may reveal personal data, but we think that the property element here is dominant, and the executor, and only the executor, should have access to such information about property in order to manage and exercise and execute the estate. The third category is copyright. Now, copyright, it's intellectual property, and if there are photographs or letters or drafts of articles and books for us, there's copyright in that, even if it's unpublished. And we assume, we suppose we have, supposedly we have the tools of how to deal with that. However, we argue that even though copyright subsists in much of these kinds of digital remains, photographs, for example, most users do not think of the photograph that they have just, taken on Instagram or whatever as a copyrighted work. So there's a tension there between the intentions, the subjective intentions of the user/photographer who is now dead, and how the law treats that content. And then there's everything else, in other words, personal data. And then comes up the big question, which we have already discussed in previous sessions, of does the law protect privacy or personal data posthumously? And there are some positive answers in some countries, Denmark and some other EU countries, which have taken advantage of recital 27 of the GDPR, extending data protection rights, some of them posthumously, or the specific sui generis laws of the kind that the Americans have in most of the states, or Catalonia, or the French law that Lucien has mentioned in the first session today. But then for other countries who do not have specific legislative arrangements for posthumous privacy and data protection, the big question persists. Should we recognize posthumous privacy? And I will not repeat the discussion that we have had so far, but I can if it comes up, if the need comes up later on in the discussion. So we just remind ourselves, we suggest to remind ourselves that legal categories are a tool reflecting various ideas, but they are not the ones that should determine what's going on. Within existing legal categories, we suggest differentiating between property, information about property, copyright, and data protection. And we are left with contract law, which means that the platforms determine much of what's going on, and contract law interacts with copyright, interacts with personal data, consent, etc. And each of these bodies has its own challenges, of course. That's it for the time being.
That's great. Thanks a lot, Michael. It's a very useful taxonomy, and I think very also novel in how you approach it. I look forward to the paper.